All right. Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Wednesday, April 3rd, 2024. We're going to start off with voting list number 25. And we're going to start off with House Bill 814.
House Bill 814 makes numerous changes to the juvenile justice process in the state, including altering the jurisdiction of the juvenile court, altering procedures relating to juvenile intake, complaints, detention, and probation, and altering provisions relating to the Commission on Juvenile Justice Reform and Emerging and Best Practices. So this is a bill that the Senate crossfile, which is Senate Bill 744, passed out of the Senate in a different posture. You have an amendment in your packet, which let me make sure I have the number correct.
Yes.
So it's number 963-023/1. So just really quickly to make a note, the way that the amendment is drafted is that it actually strikes most of the text of the bill and rewrites it. So that's why the amendment and the reprint are so long, just kind of to put that out there so everyone's aware of it. But so essentially what the amendments do is they adopt some provisions from the House bill and some provisions from the Senate bill. So I will kind of go through some of the major areas where these amendments are different than the bill that passed out of the Senate. So first of all, in terms of the expansion of delinquency jurisdiction for children's ages 10 to 12, the Senate bill expanded that to include specified gun-related offenses and third-degree sex offense. With the amendment, it would additionally include the crime of aggravated animal cruelty. Both bills contain provisions regarding what might happen when a child who's on probation has unexcused absences from court-ordered treatment programs. What the amendment does is largely adopt the House framework for that issue, which defined the term good cause in the context of current provisions, which allow for the extension of probation to include a child missing a court-ordered treatment program at least twice, and having unexcused absence, that is at least twice, unless the court finds the child has substantially completed the treatment program despite the absences. Another area of difference between the two bills was the effective date of provisions. So in the bill that passed the Senate, the provisions related to the commission went into effect on July 1, 2024, and the other substantive provisions went into effect on October 1, 2024. Under the amendment, it would be June 1, 2024 for the commission-related provisions and November 1, 2024 for the substantive provisions. Moving on to another category, there were a number of items that were in Senate Bill 744, but were not in House Bill 814, which are being left in the bill under this amended version of House Bill 814. So just to run through those really quickly, that would be the requirement that all cases in which a child fails to complete informal adjustment would be forwarded to the state's attorney. It would be the mandatory child in need of supervision petition for children under the age of 13 who are alleged to have committed motor vehicle theft. For pre-hearing detention, both bills allowed a carve-out to an existing prohibition on pre-hearing detention for misdemeanors for children who are already on probation and committed an offense which would, if committed by an adult, carry a penalty of more than 2 years. The Senate version carved out from that carve-out if the new offense was second-degree assault. So that is being left in this bill. And finally, the Senate bill required notice to the court whenever a child on probation has 2 or more unexcused absences from a court-ordered treatment program. So that's being put in the House bill with this amendment. There were some items that were not in Senate Bill 744 that were in House Bill 814, which are being left in with the amendments. And specifically, those are requiring forwarding to the state's attorney of all cases for which the child was already under supervision at the time of the new alleged offense. Also being left in is a provision requiring that county school boards have a policy on juvenile students who are on the juvenile sex offender registry. So the way that this provision was written by the House, it essentially mirrors the language that we have for 18-year-olds who are on the adult registry who are still in school. So essentially it expands those provisions requiring schools to have a policy for delivering those children an education outside of the public schools, to include students who are on the juvenile registry. And finally, the House bill contained provisions which codified the Governor's Office for Children, the Children's Cabinet, and the Governor's Office for Crime Prevention and Policy. So in this amended bill, those are now in statute. And then finally, there are a couple of things being added to the bill which were in neither Senate Bill 744 or House Bill 814. And those are, first of all, prohibiting pre-hearing detention, but not community detention, which the distinction is community detention would be like being on an ankle monitoring. Pre-hearing detention would be to be detained in a DJS facility. So actual pre-hearing detention would be prohibited for children between the ages of 10 and 12 who are are accused of committing a first-time offense related to firearms. And then the other piece that's now being added to the bill is requiring that when a child who is on electronic monitoring violates the terms of that monitoring, DJS would be required within 24 hours to give notice to the court, the state's attorney, and the child's attorney.
Excellent. Thank you very much, Josh. So I'd like to move the amendment and then have discussion on the amended bill. So I'd like to move the amendment. Senator McKay, sorry, go ahead.
Well, I was just, everything that you read there, Josh, it includes that Senator Salings for the list. Yeah. So we're good there. Okay.
It's they have to
within
do
the spirit of it.
Correct.
Okay,
that's right.
That's all I needed.
Yeah.
Thank you.
Is everyone going to move the amendment? All right. Now the bill is before you as amended, open for discussion. All right, sorry. All right. Motions for a favorable. Second. Do we need a roll call? Roll call.
Vice Chair Waldstreicher,
Yes.
Senator Sidnor,
No, and just to explain my vote, there was an article that was written in the Baltimore Banner by Brenda Wintrod, and where I attempted to explain why I voted in the manner that I voted last time. I think there was also an op-ed by former Judge Andre Davison. I think he had a co-author. Right,
Yeah.
Judge Davis. Right.
Yeah.
And I forget who his co-author was. Thank you. And I just take the position. I think what we did a few years ago was the right thing to do, and I just would hope that we would given it time to see what's going on. This is not to negate the fact that that some juveniles are committing crimes. But again, I just don't think it's to the level that it's been made out to be in the law. I just don't think that the data exists. And if you were to look, when I say if you look at some of the statements by even our state's attorneys who are quoted in this article, the data is not there. So that's why I'm a no.
Senator West,
Yes.
Senator Muse,
Yes.
Senator James,
Yes.
Senator Charles,
Yes.
Senator Kelly,
Yes.
Senator McKay,
Yes.
Senator Carter.
Thank you. No, just to quickly explain my vote. I adopt by reference everything that Senator Sidnor said. And I think that it's important to acknowledge that when your premise is wrong, your conclusion is wrong. And this bill is the product of a lot of media-driven panic. It is also based off of a lot of misinformation that was spread and repeated all throughout the interim. The bill that we had before us a couple of years ago was a bill that was data-driven, and it was a product of stakeholders and best practices and scientific data, and all of the policies that were put in that bill were evidence-based. And if we were here looking to reverse or change some of that based on actual evidence or data, I'd be 100% amenable to it, but we're not. We're here to do something, reverse something because of pressure from people that have for a long time been the ones responsible for the fact that we send more children to adult prison than any other state in the country. And we lock up more Black children and put more Black children in our juvenile and criminal justice systems than any other state in the country. And, you know, I've heard a lot of rhetoric from many leaders in the state, from the Attorney General to all leaders, I won't name them, that we have to begin to reverse our carceral nature and do better and make better policy. Well, if not now in 2024, I'm not sure when we start that. The bill, the mechanics of the bill, the technical provisions of the bill, you know, it's been said by many people, they're not really that bad and we made it better. But when you start with a pig and you put lipstick on it, it doesn't wind up being, you know, a beauty contestant. And so I have to say that I hope that in the future, this body will not succumb to this type of outside pressure that demonizes Black children, poor children, children that don't have access to all the opportunities, children that have failed education systems, disinvested communities, substandard education, broken families, many times because of our policies on locking up people, mass incarceration that has broken up families for decades and decades. I hope that we'll actually make sound law based on the data and based on the fact that we give lip service to, we want our children to have programs and services and intervention and prevention. But then we say, oh, we're going to expand the juvenile court jurisdiction though for 10 to 12-year-olds. And like Senator Sidnor said, the Banner article highlights the data that only a handful of children are affected. So this bill is more for show than it is for substantive change. And so for that reason, my vote is no. Thank you.
Chairman Smith.
Yes, and explaining my vote, I appreciate the sentiments from Senator Carter and Senator Sidnor. Two things can be true at the same time. Look, violent crime trends are down across the nation and in Maryland. Juvenile crime is responsible for less than 10% of the violent crime in Maryland. This issue has received rightfully attention, but it's a little bit, obviously it's the proportion of the problem. There's a crime perception problem, as our Senate President said a couple of weeks ago. But the components of this bill are a significant part of affording accountability and transparency in the entire process. Yes, the juvenile jurisdiction for delinquency jurisdiction is expanded slightly. That population targets a very, very small amount of the folks that are actually committing violent crime in Maryland. But I also don't want to lose sight of the comprehensive nature with which we've addressed this issue this session. $111 million for mental health supports and substance abuse supports for youth, $43 million for the Office of Children from the governor, $24 million for DJS for programming. So we've taken a very comprehensive approach at addressing this issue, and this committee and this body has taken a comprehensive approach in reversing a lot of the trends you're talking about, Senator Carter, over the last years. JJRA was one of them, but we've also done significant stuff with juvenile restoration, the Juvenile Restoration Act, sponsored by Senator West. So we've done a lot of significant things. We've got a long way to go. But I just want to say thank you for the dialogue and I think the thoughtful debate that this committee has afforded this bill. I'm voting yes. We have one absent. And so the bill as amended passes 8-2. Thank you all very much. It's good. All right. We're now going to move on to House Bill 693. Shamari.
House Bill 693 increases a certain surcharge assessed in civil cases in the district court and the circuit courts and alters the distribution of surcharge revenues in certain landlord-tenant cases. The bill establishes the Office of Tenant and Landlord Affairs in the Department of Housing and Community Development In addition, among other provisions, the bill extends the period between granting judgment for possession in favor of a landlord and the execution of the warrant of restitution. It establishes a tenant's right of first refusal and an exclusive negotiation period prior to the sale of certain residential rental property and expands the categories of eviction data that must be collected by the judiciary and provided to DHCD. Provisions that allocate a portion of surcharge revenues to a certain special fund are contingent on the enactment of Senate Bill 370 or House Bill 428. Provisions related to eviction data take effect October 1st, 2025. And so we're waiting on the final amendments, but I can run through the major changes that are made by the amendments. There's some technical changes, some removal of superfluous language, and there is also a decrease in the surcharge that may be assessed by the district court in a summary ejectment case to $43. It was $83 in the House bill as it came over to us. We removed, yes. Okay, so you all have the reprint that's just handed out to you. So the first change, like I said, we lowered the surcharge from $83 to $43. We also removed breach of lease and tenant holding over cases from the types of actions where a landlord could pass through the fees to the tenant and collect it. We also altered provisions relating to service of notice of the right of first refusal. In the House bill as it came over to us, it required that the notice be sent by certified mail, and we've changed that requirement to first class mail. So let me make sure just that we hit everything.
Landlord, 30 days, is that one?
30 days.
The landlord within 30 days.
Oh, yes, we changed the provision that the landlord is required to, that the start of the 30 days of the right of first refusal begins upon delivery of the notice, and change it to once the landlord delivers the notice to the tenant. And we took out a provision that allowed a tenant to enjoin a court proceeding that would, when a landlord does not comply with the requirements of the right of first refusal, we took out that provision that would allow a tenant to enjoin in a court that proceeding or that contract. We took out on page 24, line 10 and 11, we took out the requirement that a landlord provide proof of delivering the notice that they intended to file a summary ejectment proceeding within 10 days. And we took out the provision on page 24, lines 15 through 17, that a landlord may not condition the acceptance of a lease application on the tenant's election to receive notice under this subsection by electronic delivery. And other technical changes. And that's it.
Senator Muse.
Thank you. Just one question. I forgot, why did we change it from certified to first class? Certified at least required the signature, so you would know someone received it. First class, it could be.
Correct. There was some discussions amongst the stakeholders, and there were situations brought up where a tenant may avoid service or just not may be able to be served with the actual notice. And so with the first class mail,
I think I'd rather err on the side of making sure someone gets it than thinking that a few people would not get it. And I would like to move that back to certified and not first class.
Senator McKay.
With all due respect, I disagree. Having it as certified is just gonna delay, and I think the first class is just appropriate.
and that there was a compromise and they did agree to it. I mean, the parties have come together on that point. And so there is mutual agreement from housing advocates. And I know it was a compromise product of the work product. But Senator West. Senator West.
Thank you, Mr. Chair. Another question, but with respect to the certified thing, I know whenever I get notified that I've got certified mail, I regard it as a pain in the neck. And I frequently delay doing it for at least a couple of days, and I have to go over to the post office and when they're open and sign for it. I would guess that an awful lot of tenants would not get the certified mail because they just wouldn't go to the post office to sign for the letter. So I think the first class mail is more likely to get to them. With respect to, but my question is, Shamari, there are 3 sections at the end and be it further enacted sections here about when various provisions are going to take effect. So the main ones take effect on October 1st. Clearly, this bill would apply to any lease entered into on or after October 1st. What about leases that are currently in effect? How are they going to be affected by this bill?
My reading of that and understanding of the law is that leases already in effect would not be affected.
Would not be covered.
Correct.
Okay, thank you.
So let's move the amendment and then have further discussion on the amendment. All right. Just adopt the amendment. Everyone's okay adopting. All right. Now the bills before you, amendment, further discussion. Motions for favorable.
Second.
Do we need a roll call or is everyone okay? All right. Bill passes unanimous. Oh, yeah, sorry. Yeah, sorry.
The second amendment, Senator McKay's.
Sorry. We've adopted the amendment. We've not adopted the bill yet. So hold on. What is subject to amendment? Open Senator McKay.
So this is a concept, correct, Shamari?
Yes.
And so I'll give you the bare bones and then if you would pick up the difference there. So we had a bill that was requiring the landlord to provide the utility bill for those tenants who wanted to apply for utility assistance. My amendment would be such that a second month could be required. Right? Correct.
So yes, Senator McKay, so you would want, if a landlord and tenant agree.
Those that would have to agree.
And
that funding that would be coming from the safety net could go towards a second month rent deposit. That could be then used when life happens. Didn't delay in paycheck getting paid, a bill came up or whatever, they could pay the rent from that. But it would only be if it was both in harmony between the tenant and the landlord that they wanted to do that. It is something that we do in Allegheny County. It keeps a lot of people from getting onto the homeless road. And a gas bill is approximately like $1,400. And what it would do is, as I said, help the tenant because there would be money there, but it would also help the landlord to be willing to give somebody maybe a little bit more grace and help them fit to be a good tenant going forward.
So if I could just run some language by the
Absolutely.
committee. So if you look at page 21 of the reprints, line number 7. The amendment would read, except as provided in paragraph 2 of this subsection, new text, a landlord may not impose a security deposit in excess of the equivalent of 1 month's rent per dwelling unit, regardless of the number of tenants. Paragraph 2, a landlord may impose a security deposit up to 2 months' rent if the tenant is eligible to receive utility assistance. The lease requires the tenant to pay utilities directly to the landlord, and the tenant and landlord agree. Does that capture?
So the only thing is look at the utilities. That person, when they qualify for that, is that the utilities are already in their rent. So they're not, the tenant's not paying the utilities.
Got it.
Okay,
Okay, so.
that's what makes them qualify.
Right.
Is that it's already in their, it's in their rent.
So the tenant would have to apply.
They have to
For-
apply.
Okay,
And it would be advantageous of a landlord with somebody saying, hey, I'm coming with utility help to go for the rent. And it's putting that money into the security deposit. which would then-
Okay.
So just real quick, sorry, Senator Kelly, but I'm gonna. Go ahead, Senator Kelly, then I want to
No,
clarify
I
something.
think, go ahead, I'm fine. I just,
Look, I get it. So here, I like the concept because it's providing for an added buffer for someone who qualifies for this energy assistance. But just Shamari and Senator McKay, since the bill limits the deposit now to 1 month, explain again how that functionally works. If the law is going to say you can only require 1 month, but then you say, okay, there's a caveat here that if you agree and you're a recipient of this energy assistance, then you could park that money into a second month. Is that okay? Does that
so.
work? I just want to make sure I'm understanding, but
Just logistics, there'd be 2 paragraphs to that section. 1 month or 2 months if agreed to both parties. And the tenant pays utilities, or their utilities are included in the rent. And they pay utilities directly to the land. No,
What ends up happening is that they're awarded energy assistance then.
okay.
And that energy assistance can go towards that second month.
and you've done this before, right?
Do it, yes, sir. And we do it in Allegheny County on a regular basis. What it does is it says to landlords, here's another way to give somebody a little bit, maybe a second chance. Well, maybe the financial doesn't look right, but this is a way to get them 2 months. And it's not coming from the tenant, which I understand it's hard for them to come up with 2 months, but this is a way to
Okay,
give them
so
a buffer. But they have to, both the tenant and the landlord have to agree to it.
Senator Kelly.
thank you, Senator McKay, for explaining this. I think this is actually really cool. I would want to make sure that the language were really tight, both the if agreed to by both parties and that the tenant was eligible for the utility assistance. They had to be maybe accepted into the program or something like that. I wouldn't want anyone to accidentally get into a situation where they're being required 2 months and they're not eligible, or it's just not their preference. But if it is their preference, I think this is a lovely idea for having a little slush fund for when things get tough and you might not be able to meet your expenses, which I think is where you're coming from, right, Senator?
so
And just to be clear, the default is also that only 1 month is being required. I mean, upfront for this. Okay. Yeah.
So the language that I was speaking about, the lease requires the tenant to pay utilities directly to the landlord. That would be a situation where the utilities are a part of the rent paid.
As long as it.
That's
as long
mirrored
as
from
it's
that
From a
section.
legal standpoint, to qualify for that program, your utilities have to be included in your rent.
So we want it to be that they are qualified for the program, would be the
Correct.
stipulation.
Correct.
And
Which I
they're
think
enrolled
that's what he
program.
had said.
Qualified and enrolled program, right? I mean, like,
Yeah. Because we've already passed we heard the one bill that was requiring the landlords to give those bills
Yes.
to those people. So it kind of comes together as a tongue and groove there. They work together.
For a second. Yeah. Is everyone okay having that amendment? All right, now the bill is before you as amended. The motion is for favorable. Is everyone okay being recorded in the affirmative? All right. House Bill 693 passes unanimously with amendments. All right, we're gonna hop over to voting list 26, and what's the bill number? 1329. That's House Bill 1329 on voting list number 26.
House Bill 1329 authorizes individuals under supervision by a private home detention monitoring agency to receive earned compliance credits to reduce the period of home detention. On request by the Division of Parole and Probation, the home detention monitoring agency responsible for monitoring the individual must forward a report with specified information regarding the individual's compliance during the monitoring period to the division.
I'll second that. Is motions for favorable has been seconded. Do we need a roll call, or is everyone okay being recorded in the affirmative? All right, passes unanimously. Josh, we're gonna go on with HB 43 while Senator Sinner gets me something, and then we'll come back, and then we're gonna looks like we'll wrap up with, we're gonna start working on House Bill 1117. So we're gonna wrap that up, but we're gonna go to, got it. So right now we're gonna go on to House Bill 43.
House Bill 43 authorizes counties and municipalities across the state to designate county or municipal highways under their jurisdiction on which a person may operate a golf cart. So this would replace currently existing authorizations that apply to certain counties and municipalities. So this is the cross-file of Senate Bill 316, which is also on the voting list. The House they amended the bill slightly, so the main two changes that the House made to the Senate, to the bill as drafted, was to add an additional requirement that the number of individuals in a golf cart not exceed the number of seats. And whereas, I think all of the current authorizations for golf carts include a restriction that the golf cart only operate between dusk and dawn, the House amended their bill to additionally allow them to operate at all times of the day if, and let me read the exact language here, if the golf cart is equipped with headlights, taillights, and brake lights approved by the Motor Vehicle Administration and any other lighting devices required by the administration. So those are the main differences between the House bill and the Senate bill.
I only had questions about the nighttime stuff, so. Yeah, because I mean, just the golf carts at night, I don't know. Does that ripping around dark roads at night? What do you all think? I mean, what do you all think? I mean, I'm not, you want to conform to the Senate bill and then keep it moving? Is that the only difference between the two?
So there were Actually, there's that, and I mentioned the House bill includes this restriction, the number of occupants in the golf cart not exceed the number of seats. And then there was just a slight carve out, so the general rule would be that the highways on which this is authorized could not have a speed limit of more than 30 miles per hour. There was just a carve out for the jurisdiction of Golden Beach, Patuxent Knolls, and St. Mary's County, because their authorization is currently at 35 miles an hour, so it would just preserve 35 for that specific jurisdiction.
If you all concerned about the nighttime stuff, which I just bring up, I mean, whatever, but we could strike it. And then I like the additions that the House made. Just the nighttime thing gives me pause, but what do you all want to do? All right, let's take out the nighttime stuff then. Yeah. So can you reread it back?
If you're on House Bill 43, it's the language on page 5, lines 3 to 6 would now be struck from the bill.
Like that motion, you strike it. Senator James.
I don't think we have time, and so I don't want the sponsor to think we're not supportive, but maybe next year, if we come back and require some sort of extra lighting on these vehicles, because I think many of us are not going to even be used to that they're out there on the highway. But I don't want to jump into that because I don't know how you light up a golf cart and I don't want to make it unaffordable or hard to do, but I think maybe we should just let them know that for now, we're reluctant, but certainly we'd work with them, to change this,
Okay.
change the lighting.
Right.
And then make it safe. And then we.
All right.
All being golf carts.
So everyone's okay with that amendment? All right, now the bill's before you as amended. Motion is for favorable. We've taken up the nighttime side. Everyone's okay? All right, House Bill 43 as amended passes unanimously. Yeah. Can you, what's the Senate cost? Senate Bill 316. So Senate cross-filed the motion just to conform 316 with House Bill 43 as amended by the Judicial Proceedings Committee. Everyone seconded. Everyone's okay with that? All right, excellent. All right, one more. Give the council a question, a second to catch up, and then we're gonna go. We're gonna go on to Shamari. Where's Shamari? Okay.
Favor with amendments.
Just to give you guys time, we're gonna go with House Bill 833.
Yeah, there's no crossfire.
It was in your voting packets yesterday.
Okay, so no one's.
All right, let's. All right, we're locking on this bill, so 833. Let's go ahead. Let's head, please, council.
House Bill 833 establishes a presumption for purposes of child in need of assistance that if a parent is receiving treatment in a residential substance use disorder treatment program that has beds or services for patients' children and the child is in the presence of the child's parent for the duration of the parent's treatment placement with the child's parent is in the best interest of the child, and there is not an emergency situation that requires the removal of the child, And two, a child is receiving proper care and attention. In addition, the bill requires a local Department of Social Services to file a report with the court in certain cases when a parent is receiving residential SUD treatment. As specified, the Behavioral Health Administration within the Department of Health may require a facility that provides treatment for substance abuse disorder to provide beds and services for patients, children, and allow a patient's child to be in the presence of the child's parent for the duration of the child's parent's treatment. There is an amendment. This was a sponsor amendment, and it was in your packet, but that amendment states this subsection may not be construed to prohibit another parent or guardian, custodian, a relative, or another person able to provide supervision and care from providing supervision and care for a child for the duration of the child's parent's treatment if the other parent, guardian, custodian, relative, or other person agrees to provide supervision and care.
Senator Charles, is his amendment.
Thank you, Mr. Chair. Yeah, this was a sponsor amendment. We worked through pulling this amendment together with OPD, and so everybody's fine with this. And I think this is a good amendment, and I hope we can move forward with the favorable on the amendment.
Sure. Senator Walter, I guess question.
So I'm supportive of the bill and supportive of the amendment. It's a good bill. I just want to understand how in this case is the presumption overcome?
So I would rather defer if we could have the representative from the public defender.
Sure.
It would be overcome by when social services would remove the child, and at the shelter, they would have to present evidence as to why the baby it would not be in the best interest of the child to be at the treatment facility. So it would still allow them to remove the child, which is really what we don't want to happen. But the next day at the shelter care hearing, the presumption would be overcome by evidence as to why it's not in the child's best interest to be at the residential treatment center.
Overcome by preponderance, by what standard are we?
The standard is preponderance of the evidence at the shelter care hearing.
And it's the presumptions in favor of the state, or not the individual, not the mother. Which way does the presumption slide?
The presumption slides in favor of the
It's
mother
in
to
favor of the
overcome
mother.
the presumption.
That's right.
The department would have to introduce.
So the
evidence.
presumption's in favor of the mother, the private
Yes.
party.
Yes.
Got it.
I just want to ask a question, whoever can explain. I'm just trying to understand if you have parents who vehemently disagree about where the child should be, where one parent is in treatment. And let's say that, and the treatment does have capacity for the child. How is it for to construe this statute with this presumption when another parent comes in and takes the position that this is not in the best interest of the child and strongly believes that? How does that work out?
So, and that's what the amendment addresses. In this
Well-
body of the law, if there's a parent who is not a substance user
Yeah,
and there are no
so-
allegations
Right.
against them, the law already states that parent, it's in the best interest of the child to go with that parent.
Oh, so I didn't see that, but so that was right there. Just say that again.
That's already in statute.
And the parent who
If-
is not in substance abuse and does not.
Right.
any
If there are
evidence
no
of abuse,
allegations of
the
abuse or
presumption
neglect,
is with that
that
parent
yes,
already.
yes.
Got
So
it.
that's already in statute. This doesn't change that.
Very good, thank you.
Thank you, Mr. Chair. And to that point, what this does is it protects the other parent. If the other parent has the capacity to take on the responsibility of raising this child, it's in the best interest that this kid is with the other parent that doesn't have these substance abuse issues. They can be raised in a home and not in a treatment facility as the other parent is going through it. It's to make sure we have the guardrails in place to protect these kids and protect the other parent as well. Typically, a lot of times in these custody cases, you don't see that. It's hard to come up with a presumption to gain custody. So this puts some guardrails in place to protect the other parent.
I did not know there were treatment facilities, residential, I assume, right? That you could bring your children to. I was not aware of that.
Yeah, I just found out about it during the bill hearing too.
I mean, is that prevalent? Is that there are a lot of those? pets or-
There is, yeah, it's not a lot,
No.
but it is common practice. And we just got open, well, there was just one open for fathers as well.
I was gonna ask you if it's just
yeah.
mothers or mothers and.
Most
fathers?
of them are just mothers, but there was one in Annapolis that just opened a few weeks ago for fathers.
All right.
Move the bill.
You want to move the amendment?
Yeah, move the amendment.
Second, okay, now the bill's before you as amended. Motions were favorable. Is Reverend McKay being recorded in the affirmative? Excellent. Okay, the Senate President gave us a warning to not be late, and we have 3 minutes to get back over to the floor. So that'll wrap up voting for this session.
Yes.